How do you handle allegations of sexual misconduct in the workplace? If you have been in business long enough and you have a lot of employees, it's only a matter of time before there's some sort of allegation of sexual misconduct. This can take many forms. It might be a joke that's lewd or has a sexual undertone that's been emailed from one person to another. Maybe it was a conversation, a story that was shared over the lunch hour. Or maybe it's something more overt. For example, one employee asking another employee for a kiss or giving him a little shoulder rub. Maybe it's something even worse, like some sort of sexual assault. Pulling somebody into a room or asking them to go into a room privately and then inappropriate sexual contact. These are very difficult issues for employers to deal with, and they often ask me, what do we do to avoid liability? What's the appropriate way to respond to this? We want to be mature, responsible, reasonable, use best practices. How do we handle this? So that's what we're going to talk about today. How can the CEO, HR director, or manager protect the company, protect the employees, and handle a very difficult situation with grace and in a legally responsible manner? So let's start out first. Ideally, the company has proper policies and procedures in place that say what conduct is inappropriate. So that might be some sort of sexual harassment policy, sexual conduct policy, employee behavior policy, something like that. Ideally, you have that in writing. So for those of you listening today, step one is work with your employment attorney or HR consultant to get an employee handbook together and have clear policies on what is appropriate and more importantly, what's not. So, step one, set the standard. Make sure that that is communicated. It's provided to every employee and they acknowledge receiving it. Typically, they acknowledge that in writing, but it can be done with software as well. The second best practice is to revisit this from time to time in training. So you might have periodic training and review of the employee handbook so that it's very clear, not only did everybody get it at first, but the company elevates the importance of people being aware of it and it remaining fresh on the employees' minds. So that's not often done, but it is something that can be done, especially if the company wants to go over and above to make sure that it avoids liability for some sort of sexual misconduct that occurs in the workplace. And now, let's imagine that with that as the backdrop, some sort of sexual misconduct occurs. What is a company to do? Well, we'll walk through that, and then we'll walk through what is a company to do if you don't have that as the backdrop. In other words, you don't have an employee handbook, clear policies and procedures. You haven't done any sort of training or conversation with people. Because you still have obligations, and employees still should act reasonably and legally. You can't go assaulting someone in the workplace just because it didn't say you can't do that in the employee handbook. So, what do? Well, step one is conduct an investigation. That's a formal sounding word, but it really just means figure out what happened. And when you do that, make sure you document everything you do, because your liability as an employer is based on, did you respond reasonably in this circumstance? And so to prove that you responded reasonably, you want to document on what date, who did you talk to, and what did you discuss? What did you find out from them? So for example, you might talk to both employees who were involved in the incident to get both of their versions of the events. You might then go back and get clarification on points. So you're going to have one or more conversations with those employees. Then you document that you had those employees. I also recommend having 2 people at a minimum conduct the interview. Why? Because we don't want to get into a situation where an employee says, this is what happened, and only one of you are there. And then later the employee changes the story, and it's he said, she said. It's your word against the employee's. But if you have two people conducting the interview, that does a couple things. One, it provides a second set of memory when making notes and if there's any dispute over what was said. Second, it helps provide some accountability for the investigators. We don't want a situation where an investigator is asking questions of an employee and then the employee says, I felt really uncomfortable telling him that stuff. He kept asking questions about where was this at and what exactly happened and wanted all the lurid details. We want to avoid that, and you can help avoid that by having two people part of the investigation so that they are providing mutual accountability for each other and helping to protect the company. You should also consider having somebody of the same sex or gender as the employee who is considered the victim in the incident, so that employees have somebody they feel comfortable with that they can talk to. So now you conduct an investigation. Now you have to decide what to do about it. Well, one of the initial questions is, what do you want to do about it? Do you want to let an employee go or not? Now, obviously, you're not going to let the potential victim go, but let's say there's an alleged perpetrator. So one employee says, this guy in the company did such and such, but the guy denies it. Now what do you do? Well, do you have a legal obligation to fire the guy? Generally, no. What you do have, though, is a legal obligation to keep the rest of the employees safe. So that means handling him properly, making very clear what the violations are, making very clear what's expected for behavior in the future, and then turning to both the potential victim or other potential victims. The company has to make sure, it has a legal duty to make sure employees are safe. So if a person, for example, has a track record of sexually assaulting coworkers, you probably can't keep that coworker working there. Or maybe that person works remote only, but they might virtually, through email or through video, do something inappropriate, so usually you don't keep them. But the point is, you as an employer have a duty to ensure a reasonably safe environment for all of the other employees in the company. So think about what that looks like. That might look like training on a periodic basis so everybody is aware of it. It might look like having some sort of security cameras around in open public spaces with signs making clear that everybody knows there's a camera up there recording. Now you have to check state laws. There are state privacy laws. You want to be considerate of that. But generally speaking, in a workplace, in a common area, the employer has the right to put up cameras. In fact, sometimes an employer will have a responsibility to do that to ensure the safety of the employees, especially if there have been incidents of something occurring and the employer is wanting to discourage that sort of conduct. Another part of the investigation will be gathering evidence. That might be emails for the employees involved, might be text messages or some other chat or communication tools that the company uses. You can ask the employees to look at their text messages on their phone. Now, there are some privacy laws related to that if they don't want to allow you to. Another big question is, do you report this to law enforcement? Generally speaking, you're permitted to report it if you want, but normally employers don't want to deal with law enforcement and it feels like it's escalating an issue. So the first question is, do you want to? Do you feel like the allegations are serious enough, legitimate enough, and likely occurred? If it seems like something unlawful occurred, reporting it to law enforcement can provide some legal coverage for the employer because it shows this wasn't a cover-up. In fact, the employer invited law enforcement in to conduct its own investigation, cooperated so that justice could be done, and to preserve the protection and legal rights of everybody, potential victims, other employees, members of the community, etc. So you'll think about whether to invite the law enforcement in. Why might you not? Well, if the allegations aren't serious enough, like it's not actually illegal, even if true, it's not illegal. Or maybe you're doubtful that it is true. Things just aren't adding up. You hear one person denies it, the other person makes these allegations. But let's say the person who made those allegations has a track record of making false allegations. And let's say also a number of the parts of the allegations don't match. Like they said they were here at 7:30 in the morning and that's when the event happened, but their time card shows or their security card shows that they didn't clock in until 8:30 or they didn't enter the building until 8:30. Well, it could be that they just got the time wrong, but it also could be that they're lying. And so to some extent you might have to decide, do we even want to invite law enforcement in? Do we feel it's legitimate enough that these are reasonable allegations that should involve law enforcement? If you don't know what to do, bring in the company's attorney. Run the whole scenario by the attorney. That provides a benefit in a couple ways. First, it demonstrates that you have conducted a reasonable effort to respond to these allegations. Second, it involves the attorney. It makes the attorney a witness to the case. It also may pass on some liability to the attorney, because if the attorney says what you should do and you do that and then it goes bad, you might have a claim against the attorney for bad advice. So at the end of the day, what are you worried about here as an employer? I mean, you're probably not going to get charged with a crime. You didn't even know that one employee may or may not have done something. So what are you worried about? The law requires employers to have reasonable policies and procedures in place for employees, make employees aware of that. So reasonably onboarding, reasonably hiring employees. By the way, if you hire an employee who has a track record of some sort of misconduct, that might be a claim of negligent hiring. Because if you were negligent in hiring an employee who you should have known, if you had done reasonable due diligence, you would have known that employee was likely to reoffend, that would be a claim against the employer, so against you, for negligent hiring. The other big legal liability is negligent supervision. If you have failed to have proper supervision, that includes policies and procedures, that includes a proper response if there's an allegation of misconduct. If you have negligent supervision, the employer can be liable. By the way, what can you do about all of this stuff? One thing you can do is get employment practices liability insurance. That's abbreviated EPLI. That is usually a low-cost way to get coverage for these sorts of employment practices claims that can come up. So, and you'll want to make sure that the policy itself would cover this sort of thing, negligent supervision, negligent hiring. But the key with all of this is to protect the company from liability and help all of the employees flourish by being able to stay focused on their responsibilities at the job, not worrying about their safety, not worrying about the distraction of somebody who is making rude comments or inappropriate comments or misconduct of any sort. So, summarize today. It's bound to happen in most companies that you will have some allegations of misconduct and in particular sexual misconduct. To avoid that, have appropriate policies in place. That usually takes the form of an employee handbook. Have a good process for hiring, so you are doing a little bit of a background check, maybe not a full legal background check, but you're checking on references and the credibility of the people you hire. Next, make sure proper supervision is in place, that the rules are known. The employee handbook is reviewed from time to time. Employees are given an opportunity to review it while at work and then sign off that they have reviewed it and they're aware of all the policies. Maybe provide some training. And then when an allegation comes up, document everything, investigate it thoroughly, involve legal counsel, decide whether to report it to law enforcement. and establish a written plan to follow up with the people that were involved, so that if they are kept in employment, you have demonstrated that you very reasonably and maturely responded to the situation to keep everybody safe and to keep the employees focused on their work, not distracted by these sorts of legal things. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. I put together guides for business owners to avoid common problems in their business. If you'd like to get some of these free guides, you can go to aaronhall.com/free. Just sign up. You'll get a PDF. You'll also get access to some of the video training that I do on those topics, so you can avoid some of the common problems that happen in many other companies out there, so they don't happen to you.